Okay, good morning, everyone. I'm hoping that everyone can hear me and see the slides that I put up on the screen. For everyone that doesn't know, I'm Chelsea Carter. I'm a member of the Business and Property team at King's Chambers. And today I'm going to talk to you as part of the Young Professionals series about Section 335A of the Insolvency Act. And of course, that deals with rights and under trusts of land. Section 335A was inserted by Section 25(1) and Schedule 3 of the Trusts of Land and Appointment of Trustees Act 1996, and it took effect right from the beginning of January 1997, so it's been around for a number of years now. Now, it's the section which a bankrupt relies on to obtain an order for possession and sale of a bankrupt's property. Now, a bankrupt's home is often their main asset, the main asset in the bankruptcy. And of course, they often live there with their partner, their families. So these applications are hotly fought. Now, as we can see on the slide, I've reproduced Section 335A, just focusing on subsections 2 and 3. On such an application, the court shall make such order as it thinks just and reasonable, having regard to, firstly, the interests of the bankrupt's creditors, secondly, where it includes a dwelling house which has been the home of the bankrupt or the bankrupt spouse or civil partner or former spouse or civil partner, the court has to look to the conduct of that person, the needs and financial resources of that person, and of course the needs of any children. And thirdly, the court looks to all the circumstances of the case other than the needs of the bankrupt. Now, looking at subsection 3, where an application is made after the end of the period of 1 year, beginning with the beginning of the bankruptcy, the court shall assume, unless the circumstances of the case are exceptional, that the interests of the bankrupt's creditors outweigh all other considerations. Now, regard should initially be had to Section 283A of the Insolvency Act, as pursuant to that section, at the end of the 3-year period, beginning with the date of the bankruptcy order being made and the trustee being appointed, the interest in the bankrupt's home ceases to be comprised in the bankrupt's estate and it revests back into the bankrupt. So an application for possession and sale must be made in normal circumstances within 3 years of the bankruptcy order being made. Now, initially, again, consideration should also be given to Section 313A of the Insolvency Act, as pursuant to that section, the court shall dismiss the application if the value of the trustee's interest in the property is below £1,000. That's quite rare, but it's always worth checking and definitely knowing what the equity in the property is, and therefore what the value of the trustee's interest in the property is as well. Now, Section 335A only applies to applications made under Section 14 of the Trusts of Land and Appointments of Trustees Act, and therefore it is not engaged where the property of which the trustee seeks possession is solely owned by the bankrupt, because in that case it's Section 363 that is relevant. So Section 335A is only engaged where the property is jointly owned by the bankrupt and another, whether that be co-owned equally or jointly owned in different percentages. As a result of that, we need to be using the procedure in Rule 1.35 of the Insolvency Rules. Of course, that is a standard Insolvency Act application notice, supported by a witness statement, and of course, any supporting documentary evidence should be exhibited to that witness statement. It's very important that not only the bankrupt, but also the co-owner or other owner of the property must be a respondent to the application. And of course, as a result of that, they need to be served with the application and have the opportunity to respond to that application. The other owner doesn't always respond. Sometimes they don't get involved. But most of the time, they want the opportunity to be able to put forward their own evidence and to be heard by the court before they make a decision on the application. Now, the court will make such order as it thinks just and reasonable, having regard to the factors listed in Section 335A, subsection 2, which I've reproduced on the slide. Now, obviously, the interests of the bankrupt creditors demand payment, and payment can only be achieved where there are realisations, and realisations demand a sale of the property. Now, the conduct of the bankrupt spouse or civil partner is broad. It can include any conduct. Just a couple of examples. It can include excessive or irresponsible spending on the part of the spouse or civil partner. It can also include a refusal by the spouse or civil partner to assist the bankrupt in avoiding bankruptcy from assets available to that individual. Now, looking at the needs and financial resources of the spouse or civil partner, former spouse or civil partner, that speaks for itself. If there's evidence of their needs beyond, well, including and beyond financial needs, that needs to be put before the court. Now, the needs of any children does not merely encompass financial needs. It's not also combined to the needs of children under the age of 18. Now, in the case of Grant and Baker, which we'll come on to look at in a moment, that's where the court held that it included the needs of adult children. Sometimes, in that case, it was an adult child with disabilities who was cared for in the property. As we can also see, the court may not have regard to the needs of the bankrupt. The bankrupt may complain that they need the property. They can complain that they need it for their business, their livelihood, that they may suffer some form of adverse mental or physical consequence as a result of the property being sold, but such complaints are redundant. All we're looking at here are the points which are set out in subsection 2. Now, subsection 3, which I've reproduced on this slide, as we can see, states that where such an application is made after the end of the period of 1 year beginning with the bankruptcy, the court shall assume, unless the circumstances of the case are exceptional, that the interests of the bankrupt's creditors outweigh all other considerations. Now, there's 2 points to bear in mind here. The court will not be receptive to arguments which are based on nothing more than inconvenience. So we need to be looking and drawing a distinction between inconvenience and exceptional circumstances. And of course, each case will be determined on its own facts. So it's therefore optimal if a trustee makes an application more than a year after the date of the bankruptcy, because of course, at that point, the interests of the bankrupt's creditors outweigh all of the considerations, unless we are looking at a case of exceptional circumstances. Exceptional circumstances is a rebuttable presumption, and it is a high hurdle to jump. Now, the case of Dean and Stout, a High Court case from 2004, summarised the principles that the court should follow when considering whether the circumstances of the case are exceptional. We can see here, firstly, the presence of exceptional circumstances is necessary to displace the presumption, but the presence of exceptional circumstances does not debar the court from making an order for sale. So even if they find that exceptional circumstances exist, they can still proceed to make the order for possession and sale. Now, secondly, exceptional circumstances typically relate to the personal circumstances of one of the joint owners, such as a medical condition. Thirdly, the court will make a value judgment after looking at all the circumstances. There are no defined categories of exceptional circumstances. So although previous case law can sometimes be helpful, especially if it is on all fours with the facts of your case, they're not always helpful because, of course, every single case turns on its own facts and there are no defined categories. Fourthly, exceptional circumstances are outside the usual, and I quote, melancholy consequences of debt and improvidence, and they are compelling reasons not found in the ordinary run of cases. They're just simple quotes from the well-known case of Recitro, which I have referenced at the bottom of that slide. Now, fifthly, it is not uncommon for a partner with children to be faced with eviction in circumstances where the realisation of their beneficial interest will not produce enough to buy a comparable home in the same neighbourhood or elsewhere. Because, of course, this is just an example of the melancholy consequences of debt or improvidence, and it's not considered exceptional. Also, in a few cases that I've dealt with, the courts has considered that it is not exceptional when, upon a sale of the bankrupt's home, their partner will be forced to rent a home for themselves and their children, whether that be in the same area or elsewhere. Now, sixthly and finally, for the purposes of weighing the interests of the creditors, creditors have an interest in the order for sale being made, even if the whole of the net proceeds will go towards the expenses of the bankruptcy. The fact that the proceeds will be swallowed up in paying the expenses of the bankruptcy and that nothing will be left over for the creditors is not exceptional, and the court is aware of that. Now, there's a helpful summary of what exceptional circumstances are in the case of Hosking and Michaelides. Don't know if I'm pronouncing that right. It's a High Court case from 2004, where it was simply stated that exceptional means a circumstance that is out of the ordinary course, or unusual or special or uncommon. However, to be exceptional, a circumstance need not be unique, unprecedented or very rare, but it cannot be one that is regularly or routinely encountered. So an easy test: if you have heard of the circumstances being described on a number of occasions, it is highly unlikely they are going to be considered exceptional. Now, examples of exceptional circumstances which I think can be helpful. We've got the case of Martin, Sclan and White from 2007. The bankrupt's partner was an alcoholic, and they had a support network available through the neighbours and a local relative to assist with their two children, aged 11 and 14, and the poor state of the property. Now, this decision was made for the purposes of the equivalent provision in Section 3376 of the Insolvency Act, but it's still directly applicable in relation to exceptional circumstances. And in that case, there was clear evidence of the support available due to the location of the property. And of course, if the family were forced to move, the local relative wouldn't be nearby, and their support network in the locality through the neighbours would not be available. And so the court took that into account and decided that that did amount to exceptional circumstances. We've also got the case of Grant and Baker, 2016. This is a case that will pop up throughout considering these applications. In this case, the bankrupt's disabled adult child was cared for in the home, and it was considered that those circumstances were exceptional. We've also got the case of Pickard and Constable from 2017, another High Court case. And in that case, the bankrupt's husband lived in the property and suffered from a serious autoimmune condition. So those are just a few examples of what is considered exceptional circumstances. As you can see, it usually relates to medical conditions or conditions such as alcoholism with extra factors involved. Now, just 3 examples of where the court has considered the case and circumstances not to be exceptional. We've firstly got the case of Barker and Mears, High Court case from 2004. In that case, the bankrupt's son lived with his mother in the property and had special educational needs that the bankrupt and his partner said were helped by the mother and the child living in that specific property. Now, the court found that the son's educational needs or problems were not severe, and that it was unclear if the mother's ability to help the son would be impaired as a result of the sale, and if so, to what extent. There was a clear lack of evidence here, just an assertion that the move would disrupt the care that the mother provided to the child who had special educational needs. The next case is Donahoe and Ingram from 2006. In that case, it was possible for the bankrupt to make full repayment of all the debts, including all statutory interest, but over an 11-year period. That wasn't acceptable. It was too long of a period. I can't say or answer the question that I anticipate will be asked. How long of a period may be allowed? I don't know. I think it would have to be a reasonable period of time. We're not talking years here. We're probably talking months. But in any event, an 11-year period to pay all the debts plus interest was far too long to warrant the court making a finding of exceptional circumstances. We've then got the case of Lyle and Bedborough, High Court case from 2021. In that case, the bankrupt used the property for his business and argued that it was not practical to run that business from a smaller property into which they would have to move if that property was sold. Also, in that case, the bankrupt's wife had a diagnosis of polymyalgia. Now, the court held that the business issues were just an example of the ordinary consequences of a sale following bankruptcy, and that the bankrupt's wife would suffer the symptoms of polymyalgia wherever she lived. And there was no suggestion that the property had been specifically adapted for her and her condition. So it made no difference whether she was effectively suffering in that property or another property. Now, once the court has decided whether they are exceptional circumstances or are not exceptional circumstances, and they are going to move on to make an order for possession and sale, they can consider a postponement. They have a power to postpone the date for possession if warranted by the circumstances, and the length of time is at their discretion. Now, I've used the same 3 examples in order to have some consistency, so that you can understand where a court has found exceptional circumstances exist, how they then view a potential postponement of the order to be made. So we'll look again back at Martin, Sklan and White. In that case, the courts held that the exceptional circumstances justified a postponement of an order for sale for a period of 7 years until the bankrupt's youngest child turned 18. So ultimately, they were protecting the children here. Both children up until the age of 18 required the support network in the locality of the property, and therefore it was appropriate to delay the possession and sale until the time that both children turned of adult age. We then look at the case of Grant and Baker. Although the circumstances were exceptional, an indefinite suspension until the bankrupt's disabled adult daughter no longer resided at the property was held to be incompatible with the underlying purpose of the bankruptcy code. Now, in all but the most truly exceptional cases, the purpose of the code requires realisation within months rather than years. Now, in that case, the court found that a 12-month suspension was appropriate. And so you'll start to see a pattern develop here, that even where circumstances appear to be, to us, extremely exceptional, we're still only looking at, for example, a 12-month suspension to an order being made, because ultimately the creditors need to be paid. And where the application is made a year after the bankruptcy, the interests of the creditors are paramount. Now, looking at the final case here of Pickard and Constable, a suspension of sale until the death or earlier vacation of the property by the bankrupt's husband was not appropriate. Again, the court found that a 12-month suspension was appropriate, with liberty to apply to vary the date of possession and rely on further evidence if necessary in the future. So again, a 12-month suspension, even though we were looking at a serious autoimmune disease of the bankrupt's partner who lived in the property. Now, that's not to say that indefinite postponements don't exist in what are often referred to as truly exceptional circumstances, but I will say they really are rare. And the example this is often looked to is the case of Clawton and Charalambous of 1998. Now, in that case, the bankrupt's wife suffered from chronic renal failure and chronic osteoarthritis. She could only walk with great difficulty in the aid of a Zimmer frame. She spent most of her time in a wheelchair. She was 60 years old and she had a reduced life expectancy. Now, importantly here, the property had been adapted to her needs, and therefore the court held that it was appropriate to suspend the sale until the death of the bankrupt's wife. So I think it's important here to note the property had been adapted to her needs and the reduced life expectancy, because what we were looking at here wasn't a case of, say, for example, 10 years, 20 years. It was much less than that. And ultimately, within a few years, the creditors were going to get paid. So it is possible for the court to make an indefinite postponement, but the cases would have to be truly exceptional. And I really don't think we would be looking at long periods of time, a few years here and there, but nothing extremely significant. Like I said, nothing towards the 10, 20 years. This is a case that relates to occupation following an order being made. It's a case of Howlader and Moore, 2021. In that case, a court held that a court may allow a respondent and their family to remain in occupation of the property until after contracts for sale have been exchanged, if appropriate, on the facts of the case. Now, in that case, we were looking at a working farm, a property on a working farm. And there was no evidence before the court in that case that a vacant property and vacant farm would sell faster or for more than a property that was lived in and a farm that was operational. So they were very specific circumstances. But when you are looking at a property, it is a farm, or for example, I've had a case where it was just simply a property where they had a lot of animals. farm animals, but it wasn't an operational farm. And the court in that case allowed the family to remain in occupation because, of course, where were the animals going to go? They had a number of cows, pigs, sheep, animals like that that needed to be looked after, and they needed to have the time to rearrange for those animals to be moved and to be looked after safely. And they're the only examples in which I've dealt with and where the family had been allowed to remain in occupation. But I anticipate that this could be relied on in all the circumstances. So it's just important to bear in mind. And just finally, very briefly, turning to equitable accounting, because of course questions may arise as to whether the trustee in bankruptcy can charge an occupation rent to be paid by the non-bankrupt party. This is often the wife of the bankrupt, or I should say the partner of the bankrupt, usually when the relationship has broken down, remaining in the property which they co-own. Now, equitable accounting is not to be confused with an inquiry into the extent of the party's beneficial interest in the property. It can only be undertaken once the interests have been determined. So you have to go through all the usual rules of stack and Dowden, etc., work out the beneficial interest, and then you can turn to equitable accounting. In an ordinary cohabitation case, it's only likely to come into play in respect of the period following termination of the relationship between the co-owners. That's not an absolute rule, though. It can sometimes apply prior to the breakdown of the relationship, because, of course, the court does have a broad equitable jurisdiction to do justice between the parties who own the property. I don't have time to go through all of equitable accounting. It could probably take up its own talk. But just for reference, in case it applies to a case that you are dealing with, see the relatively recent case of Davis and Jackson for a comprehensive review of the current position in relation to equitable accounting. And that brings us to the end. I usually have an end slide, but it's not there. So thank you so much for listening. If you do have any questions, please feel free to leave them in the comment section or the question and answer sections on Zoom. I will have a look at the end or in a few minutes. And if there's anything that I think will be helpful, what I will do is I will add those questions and my answers to the slides that I've prepared, and I'll provide a copy of that PowerPoint to everyone who signed up for this webinar. So thank you very much. I hope you have a good day and you will receive the slides in due course.